Welcome to litigious California, where you need to make sure that you cross your T's and dot your I's because unfortunately it is a lot more resident friendly than landlord friendly. I don't want you to be sued. I want you to have an asset. I want you to be able to create a habitable home and have happy residents that stay for a long time. Being a landlord is amazing. There is so many ways you could win. It's really exciting when you provide homes for somebody that can't afford to purchase. And having that relationship with the residents is awesome, but it is also very scary at the same time. Being a landlord, especially in San Diego County, especially in California, you need to make sure that you keep up with all the latest laws. That's the reality. And the laws are changing every single day. We have federal laws, we have state laws, we have county laws, we have city laws, we have laws within our own HOA communities. You need to make sure that you understand what supersedes the other laws, especially if they're conflicting, because a lot of laws conflict with each other. And that you still have to learn and try to be able to be a lawyer and understand the legalities or the interpretation of these ordinances and laws. Let's talk about California and rent control. Is your property a rent controlled property? California basically says that any property that is 2 or more units, or if that property is owned in a corporation, not like an LLC where it's Danielle Brooks LLC, but like a McDonald's, like a corporation, then you're considered a rent controlled property. The exception is if you live in a duplex and you live in one of the units, or you live in the main house and you have an ADU, that is not a rent controlled property. So a rent controlled property basically is 2 or more units where you don't live in them and you're renting out 2 units in the same parcel or same conjoining parcels altogether, and you're renting them out. You are capped on what you can charge for rent increases. So it is 5% plus CPI, and that index changes every single year. So it's 5% plus 3.3%, or whatever the area says for San Diego. You're capped at 8.8% right now, right? But that has an ending date. So you can't say, I'm going to do a 10% increase because I've decided to be a nice landlord. And because you've been a resident for 10 years, I'm going to increase your rent by 15%, but you're actually 30% under market rent. You can't do that because it's a rent controlled property. You're capped out the amount of rent that you could charge. If you decide to implement RUBS, which is ratio utility billing, you can't just say, hey, I'm going to charge you that rent controlled cap at 8.8%, plus I'm going to charge you a proration of the water and sewer bill based on occupancy. You can't do both at the same time because they're all included into rent. And you own a rent controlled property, so therefore you can only do 5% plus the CPI. And you need to make sure that you know what that cap is. Because if you don't do that, you could find yourself in a lawsuit. Now, on top of that, you need to say in your leases that you are in a rent controlled property or not. So it's super imperative that you have that paragraph and it's up to date for the 2025 laws. And that paragraph is exactly what needs to be on every single notice, on, move out notices, etc. And that you abide to the laws. Or do you have to pay 2-month relocation fee? Do you have to ask a resident to vacate due to just cause? You can't just say, hey, the lease is ending and have a good rest of your day. If you live in the city, if your property is in the city of San Diego, the city of Chula Vista, or Imperial Beach, you need to understand that they have their own resident protection ordinances as well. So not only does it matter if it's a rent controlled property or not, you have these other stricter criteria. And you as a landlord, whether it's a single family residence or you're renting out your mobile home or your ADU, you need to provide different pamphlets and different disclosures. The tenant protection ordinance in the city of San Diego, the Chula Vista guidelines, the Imperial Beach guidelines. And you can't just say, hey, the lease is ending, you have to vacate because I didn't like your dog, or I didn't like your personality, or it was a legal lease, meaning a 12-month lease with an ending date. And I have every right to say, no, I, want to find a different resident. You can't do that because you have to have just cause now. Just cause varies per city. In the city of San Diego, you need to do just cause, meaning you're selling the property, you or a close family relative is moving back into the property, or you're doing substantial repairs to the property. Those substantial repairs have a cost per square foot basis, and they have certain guidelines, meaning like you have to get permits, etc. So it's kind of like rule of thumb, you're spending $50,000 or more on construction. So you have to be very careful. You cannot just say, hey, lease is ending, time for you to vacate. You have to have just cause. So is your property rent control? That's a huge law, huge ordinance that you need to know about. That's California based. But then you have these 3 cities, for example, that have their own resident protection ordinances, and they have different guidelines. So if it's a rent controlled property, meaning like a duplex, and you're asking them to vacate because you're selling the property or you're moving into one of the units because you want to downsize, you have to pay them 2 months of living expenses to move back into your home, because that is the law. I don't make these laws, we just need to abide to them. So it's super, super important that as a mom and pop landlord, you're not just saying this is what the lease says, so it's all like everything's valid. It might not be valid. What you had written 6 months ago might not still be the latest laws today. When you're doing a security deposit, that's another thing that I highly recommend that you understand, because you have 21 days to send out the security deposit. If you don't send out the security deposit when they vacate and they give you 100% possession of the property within 21 days, they could ask for double the security deposit minus, and it doesn't matter how many expenses or past due rent they have. If you don't send it out or an estimate within those 21 days, you're going to lose in court. Well, even more so, the new law basically says that you have to have your move-in photos, your move-out photos, and proof that you did do the repair. Now, I highly recommend this being best practices, how it's always should have been. But if you don't provide those links or those photos, you can't charge a tenant. You can't charge a tenant for $300 for a cleaning bill and not subtract some normal wear and tear. There's shelf lives. There's that clause, normal wear and tear. So you can't go apples for apples like you did before. You can't just say the property was dirty. You got to say, I cleaned the stove, cleaned the windowsills, did this, did this, did this, did this, and provide the move-in photos of that stove, of the windowsills, provide the move-out photos of the dirty stove and the windowsills, and provide proof from the cleaning company that the stove and those windowsills were super clean as to the original. But that 300 to 300 you can't do. You need to prorate it. So maybe you're doing 300 in the very beginning is what you originally paid for the cost of cleaning. You paid $300 when the resident moved out. So now you're charging them maybe $270 based on a certain proration that you have that's written prior, because you want to have everything in writing. So what you do for one, you do for all. And so you need to make sure you have the systems in place. Security deposit laws have changed. Before, after, fix. You have to provide the photos and the links. That is the new law. When you're screening for new applicants, you can't just have 5 different applicants apply and pick the best one and say, sorry, other 4 applicants, I'm returning, you didn't make it, you weren't picked. Have a wonderful day. You can't do that anymore. You have to, if you screen 3 groups of applicants and you have your written criteria and you choose the best one based on your written criteria prior, and you screen the other 2 applicants, you have to return 100% of their application fee. 100%. Even if you screened their applications, you can't just give them a proration back. You have to give 100%. You have to give them their credit report. So make sure that you document everything. Make sure that you treat your rental property as a business. And personally, for me, I highly recommend that you hire a property management company that needs to navigate these crazy laws, these crazy ordinances, these crazy times to make sure that we're in compliance. I don't think anybody's trying to harm a resident, a landlord, anybody. It's just trying to interpret what the law is, what the ordinance of today is scary. And so to have somebody to be your CFO, your chief financial officer for your business, for your 123 Ash Street, for your asset, really is a huge peace of mind. You need to have a peace of mind. You need to treat it like a business, and you need to make sure this remains an asset, not a liability. That's all for now.